So welcome today. I'm going to probably ask some questions at some point. Feel free to jump in. I'd love to hear from you what you know about IP and what your knowledge is. I understand from Marilu that most of you are working in artistic fields, in the arts, and in collaborative works. So today I want to do a quick overview of IP with you, and these are some of the objectives I have that I want to cover. First and foremost, just go through some basic definitions. When we talk about patents, trademarks, like what exactly is it that we're talking about? Take an overview of some basic principles and vocabulary so that in the future, when you are in a situation where you need to discuss your rights, you'll at least be able to communicate efficiently and effectively. And go through a couple of different types of IP. I understand, as I mentioned before, that most of you are working in the arts, so I'm going to put a little bit more emphasis on copyright because I think that will probably be the most pertinent for you, and go through some other forms of intellectual property, trademarks, patents, industrial designs, and if we have a few minutes at the end, just do a really quick overview on trade secrets. So on that note, let's jump right in. So what is intellectual property? There's a number of definitions that you'll likely come across, but the most popular and the most widely accepted, I would say, is intellectual property being defined as the legal protection of intangible products resulting from the inventive and creative activity of the human mind. And intellectual property is a right that allows its owner to protect itself against unauthorized appropriation by a third party, so that's la contrefaçon, as we say in French, or to allow other people from stealing those rights and to allow yourself to get a legitimate profit from it. So there's some main concepts here. We've got legal protection that is either under the law through registration or under what we call common law rights. So the existence of the work itself can be protected, as we're going to see shortly in copyright. Intellectual property is of its nature intangible. So it's an idea or some relation to those ideas and the rights that flow from that. And it needs to be some creation from the human mind. So some intangible work of the human spirit. And we're looking to protect these rights from third parties who want to copy or use them illegally. And we also want to give you the opportunity to commercialize them, so to make money off of these rights. So we're going to look at how to fix them, in a physical format, I should say, and how to commercialize them. There are a number of different types of intellectual property, and these are just a few on the screen, but just know that there are many different types of intellectual property protected by the law. There's also a distinction between what we call hard IP, so that would be the rights you would see on the screen, and soft IP, which would be any related rights. It could cover trade secrets, it can cover secret formulas, recipes, et cetera, et cetera. So let's go over just a couple of the most common intellectual property. So we've got copyright, patents, trademarks, and trade secrets. What kind of quote unquote property do these rights protect? Well, copyright is the expression of ideas, not the idea themselves. And we're going to look at this a little bit more closely in a few moments, but the expression of the idea is what it gets fixed in a physical format. So, for example, if you write a love story, that fixation of the love story in a book is what would be protected by copyright. That doesn't mean that no one else in the world can write a love story. It just means that that particular fixation is what's going to be fixed. Patents is a little bit different. They're looking at invention, something that is useful, something that is new. So imagine the person who invented the first computer, the first iPhone. That would be something that would be covered by a patent. Trademarks is something you would encounter more in the marketing field. So trademarks are popular brands that you can think of, like Nike, Apple, etc. Trademark is closer to what we would call association of a certain name or idea with a good or service. So your identity as a corporation or your identity as a person tied to what you are doing in a commercial sphere. Trade secrets is the last category I want to touch on, and trade secrets are, as the name entails, a secret. So it's all information that you would, for whatever reason, need to keep secret in order to keep the existence of that IP alive. So what does that mean? Think of a secret formula that they use to make Coca-Cola, for example. If that secret formula were known, then competitors would be able to make the same product. So by its nature, it needs to remain secret. It is intellectual property, but it's intellectual property that would be protected a little bit differently than the other three categories that we looked at, because it would not be registered. You would have to have internal protections such as agreements, very high security, that sort of thing to protect the trade secret. So it still exists, but it's protected a little bit differently. So let's jump right into the first category, copyrights. So what is a copyright? We spoke about it briefly before. It's the creation of an original work that entails a copyright. Copyright does not protect ideas, but only the form of the expression of the idea, so the physical fixation of that idea. Therefore, in order for the copyright to attach to a certain work, it needs to have what we call a fixed form. So it needs to be fixed in a literary form, a musical form, some kind of form that is no longer intangible. If your idea is just an idea format, so in other words, it's still in your head, then the copyright wouldn't necessarily attach it. It has to be even written on a napkin. At that point, once it's fixed, then your copyright rights begin to exist. And I like this little picture of Magritte, ceci n'est pas une pomme, because it illustrates the point quite nicely. What is Magritte telling us? This is not an apple. No, it is not a real apple, as you and I would know the fruit. This is an interpretation of what an apple is, and it's a physical fixation of the idea of an apple. So in this example, the copyright would exist for the painting of the apple, but would not cover all apples in existence, meaning that another person can do another picture on an apple and they would have their own copyright that would attach to that particular picture. So what exactly is copyright? Well, as the name suggests, it is the right to stop other people from copying your work. What does that mean practically, though? You, as a copyright owner, would have the right to produce, reproduce, translate, perform in public, or publish a work. You would be able to convert the work from one category to another. So this is often what we would see, people who write books, for example, and then want to turn those books into a screenplay or into a movie. You would have to go to the person who wrote the book, the author, and obtain the rights from them in order to make that conversion. So that would fall under the copyright sphere. You would also detain the work to communicate the work to the public by telecommunication. So that's everything that falls under broadcasting. Oftentimes, if you are the person who has created, for example, a television show, you would have likely to approach a broadcaster and then sell your broadcasting rights to them, because that all falls under the umbrella of the copyright, unless your contract provides that there's some kind of a split with them or some other way that the rights are divided. That's another issue, but just know that generally speaking, copyright does entail that right to communicate the work to the public by telecommunication. It also gives you the opportunity to rent the work. Now, what do we mean by rent the work? Normally, you would see that in the form of a license. So you, as a copyright owner, would allow somebody else to use your work, and you would enter into a license agreement with them that would lay out the terms and conditions of how, when, where, why, and how long you would be able to use that work. Also, as the copyright owner, you would have the authority to authorize any of the acts that we just discussed, meaning that, for example, let's say, and this is a very common thing that people do, is as the copyright owner, you're not necessarily the person who wants to publish the work, who wants to communicate it by telecommunication. Then you would nominate someone to do so on your behalf, and you would give them the authorization to delegate your copyright on your behalf. So that is another very common thing that we see in the industry, particularly when you have trusts or different corporations that get involved in helping artists generate rights and basically mandate their rights. So where would we normally see copyright in terms of creation of original works? Well, we can think of artistic works like paintings, drawings, maps, photographs, dramatic works, think of theater plays, musical theater, literary works, so books, dictionaries. Literary works also includes computer programs. So for example, software can be subject to copyright. Musical works, songs, and the like, orchestral works, cinematic works, so films, television shows, and even compilation and what we call collective works. So that is anything that is created with two or more artists, but also can mean works that are created from bits of other works. So if you were to make a painting or a picture where you cut out a bunch of images from a magazine, for example, you have created a new work. So that new work, with the collection of all those little pieces from magazines, would have its own copyright. In order for copyright to attach to something, though, it must be what we call an original work. So what does the concept of original work mean? It needs to originate from the author and is not copied from another work. So in our example of taking little bits of magazine and putting it together to create a new work, how would that work? Because the argument could be made that you're taking pieces of an existing work and putting it together. Well, the court would look and think, okay, does the new work with all those pieces assembled come from the product of the exercise of the author's talent and judgment? Meaning, are they arranging those new pieces in such a way to create a completely new work? If the answer is yes, then copyright would attach to it. If the answer is no, and they've just literally copied something straight out of a magazine, stuck it on a canvas, and maybe painted it blue, there it would be a difficult argument to make that it's a new original work. So now that we know what can be copyrighted, what would not be able to be copyrighted? Well, you've got some examples up on the screen. Titles and short word combinations generally wouldn't be copyrighted. So, and this is a bit of a touchy issue. A title in and of itself, we understand, cannot be subject of copyright protection. However, if we take the title as part of the work, the title does fall under copyright, but it needs to be connected to the work. So for example, if you have a movie and the name of the movie works together with the movie, doesn't exist on its own, then it would fall under the same copyright protection of the movie. But if you just had a title and wanted to only attach copyright to that specific title, then we wouldn't be able to attach copyright to it. And the reason why is because we're kind of falling a little bit into what a trademark would be. The question at this point is, are you really trying to get a copyright over your title, or are you trying to do more of a branding exercise, which would fall under a trademark? If the latter case, then you are much better off trying to get a trademark protection, because it'll protect you for what you're trying to do, rather than getting a copyright, which is more reserved for literary works. So ideas, as we discussed before, copyright really attaches to the physical fixation of a work and not so much the idea. So just because you wrote a love song doesn't mean that you can stop any other person in the world from writing a love song, but you can stop them from copying your love song. Names and slogans, this is again, much like a title, would fall more under trademarks and not so much copyright. Same thing for methods. Methods aren't really a physical fixation of a work. It's not really an artistic work as we know them. It's more like a method of teaching or method of sculpting. That wouldn't necessarily fall under copyright, but we'll see later. There may be some openings to have those protected under patents, as we've seen some major corporations do for business methods, and we'll touch on that a little bit later. Plots and characters is a similar thing. You can protect your specific plots for a specific movie, but just general love plot that you can think of American movies that will repeat the same plots over and over again with different characters, different settings. That's not really copyrightable, and that's one of the reasons why we keep seeing the same movie formats repeated over and over again. And factual information, that is also not copyrightable. Anything that falls under facts, ideas, news, these are all considered part of public domain, and they are everyone's property. So one person cannot hold a copyright on them. However, if you've got layouts and the like, you can protect those from copyright. Sorry, my PowerPoint is not obeying me. There we go. Okay. So some key elements of copyright. Where can your copyright exist? So if you register your copyright in Canada, it exists for the territory of Canada. You have to know that there's no such thing as a global copyright, and this is true for all IP rights. There's no such thing as global rights. IP is really territory specific. So wherever your copyright exists and where it's registered is where you're going to benefit from the protection. Canada and many countries join into international treaties. So there is protection of copyright under those treaties. So what does that mean? As a member country of these treaties, you can apply through the treaty to get IP protection in a number of countries. It's important to know that there's fees attached to every copyright registration. So if your intention is to get copyright protection in, let's say, for example, all of the European countries, it is advisable to really take a good look at what your overall business strategy is. If your intention is not to have your copyright used in Germany, then there's no sense in getting that registration. But if you're licensing, for example, film rights and you need those global rights, at that point, then it's worth it to look into a larger territory for your copyright. So how long does copyright last? Well, in Canada, normally the duration is the author's life plus 50 years. And then you would ask the question, well, what happens once the copyright is expired? Well, at that point, it falls into the public domain, which means that the public can use your work without violating your copyright and making changes to it and copying it. Some key elements for copyright. So it's important to note that copyright is actually split through two different aspects. You've got your economic rights and your moral rights. So these are two branches of your copyright. Let's take them one at a time. So in your economic rights, you've got the right to produce, to reproduce, to publish, to perform, to make public performances, to translate the work, to adapt the work, to communicate to the public by telecommunication, and to exhibit. So what do all of these rights have in common? Well, as you can tell, these are all active things that you can do to commercialize your copyright. All of these are ways to pull a profit from your copyright. So all of these fall under economic rights. And the important of the distinction is that economic rights and moral rights are different in the way they're treated. Before we jump into that, let's take a quick look at what a moral right is. So moral rights are intimately tied with the author. They are rights that flow from the legal personality of the author, and they're attached to that person. These are rights that are, like, for example, the right to be associated with the work, or the right to remain anonymous or use a pseudonym if that is how the author operates, and the right to maintain the work integral, so the integrity of the work. Like I mentioned, these moral rights protect the link between the author and the work. And they're not necessarily rights that you can get a profit from, unlike the economic rights. So why do we have this distinction? Well, one of the most important things you need to know about moral rights is that they are not transferable. They protect the link between the author and the work. However, economic rights are transferable, which makes sense because if you're trying to pull a profit from your copyright, you would need to have that option to transfer your right or to sell your right or to give away those rights. Important to know that moral rights, although they cannot be transferred, they can be waived in whole or in part. So that means that you as an artist can say, I acknowledge that I do have moral rights, but I will waive them so that I will now no longer be associated with the work. Important to note that an assignment, meaning a giving away of your economic rights, does not automatically waive your moral rights. You really need to do this in two separate steps. So if you're trying to sell your copyright, step one would be to assign the economic rights. Say, I give you my right for X amount of money or however you want to do it. Step 2 would be I waive my moral rights. Now, if you are working in a company, or you're employed, or you're a contractor, you will often be asked to waive your moral rights if you are creating a work for somebody else. This is very common. This is very normal. This is not a moment for alarm. The reason why they will ask for you to waive your moral rights is so that they can then use your work as part of their company, corporation, event, whatever it is that they're doing. And so that they can do whatever they want with the copyright without having to keep coming back to the author and being and asking them with respect to, did I violate your moral right? Can I have your permission to do X, Y, and Z? So like I said, it's a very normal thing to be asked to waive your moral rights, but you can see this as an opportunity to maybe negotiate with the person with whom you're creating the work, or for whom you're creating the work. You can say, listen, I will give you my waiver of moral rights, but in exchange, can I have your permission to, for example, use my work in my portfolio? Can I have your permission to display my work on my website? And I can put a little disclaimer saying this work was made in the context of this employment and the rights belong to X person. So these are all little things that you should think about when you're negotiating for economic and moral rights with an employer or a contractor. So let's do some practical cases. Let's look at what the copyright would entail specifically for the moral rights. So there's a very famous case in Canada called Snow v. the Eaton Centre. I don't know if any of you have been to Toronto and have seen in this image on the side the birds in flight. So if you haven't, there's a beautiful sculpture in Toronto with geese that are flying, and they look like they're about to land, and it's quite a large display. At one point, the Eaton Centre decided that it would be very nice for Christmas to put bows and garland all on these geese. So the author was extremely upset, the creator of the work, the sculptor, and he took the position that this is a blatant violation of his copyrights. Now, I want to know from you, what do you think? Do you think that by putting garlands and little bows on the geese, was the author's copyright violated? Keep in mind that at the point when this was done, the rights had been sold to the Eaton Centre. The Eaton Centre was the legal owner of the works. They owned the sculpture, and they had the right to do what they wanted. They owned the economic rights. So I don't know if anyone's brave enough to try and answer the question, yes or no, is this a violation of copyright?
I could try.
Yes, please.
I think it was a violation of copyright because that the author had moral rights. Like that's a case where he was still able to make final decisions on the work because they weren't transferred over, but I might be misremembering.
Excellent. Very good answer. So the answer is, as Doug has very well pointed out, yes, this is a violation of the artist's moral rights. Good job. So let's just understand a little bit of why this is a violation of the artist's moral rights. So one of the things that, as we talked before, is part of the moral rights is the right to the integrity of the work. That means that the work as it was created needs to stay together in a whole. So the sculptor was able to successfully object to the Eaton Centre's decorating the Christmas garlands of his creation because it violated the integrity of the moral work. His position was that the sculpture was a naturalistic creation. So by adding garlands and little bows to the geese, it was made to look ridiculous, and it would be equivalent to hanging earrings on the Mona Lisa. So even though the geese had been paid for and sold, that only affected the economic rights. The author was still able to break through that transfer of property barrier and bring an action against not only the Eaton Centre, but even the subsequent owners, because they infringe his moral rights. and they attacked, and the artist described this assault on his moral rights as an attack on his artistic integrity. So one thing that you can remember is that when you create a work, you have a moral right to the integrity of the work. If it is not presented and displayed as you had intended it, you may still have a recourse. Thank you very much, Doug. Yes.
I have a question from Louise.
Yes, I'm listening.
Yeah, hi. I was wondering about, for example, for painting, for framing, if I sell a work and the person wants to frame it, technically it should be okay. But what if like the frame is really ridiculous or something and like is impacting the integrity of my work? Would it fall into that like copyright thing?
That's a very interesting question. So one thing that is important for you to know is that copyright is a very, very, very factual based question when we get to court. The law exists, but it exists in such a way that depending on what the facts are, the judgment can be different. Okay. So if you're telling me that it was presented, it was framed in such a way that violates the integrity of the work, that makes the work ridiculous, and it is not as it was intended to be presented, you may have a good case for violation of moral rights. But there's also other factors that will come into play. So if this person frames it in a ridiculous way, but it's in their basement and nobody sees it, okay. Is your artistic right really attacked? Is your artistic integrity really attacked? In this particular case, Snow v. the Eaton Center, the Eaton Center is a huge, very public place. So they're displaying it in a very public way. So the author had a lot of ammunition to say, listen, my integrity is violated. They're making my work look absolutely ridiculous. We need to fix this. So keep in mind, it's a very factual question. You need to take consideration of the situation. How public it is also something that needs to be considered. And when you find yourself in such a situation, the best thing you can do is as soon as you see the problem occurring, start taking as much evidence as possible, pictures, who saw it, emails, etc. Does that answer your question?
Yes, thank you.
Very good. Let's take a quick look at ownership of rights. So, who can claim ownership of a copyright? As you probably guessed, the author is often the first owner of the copyright. And that's the general rule in the law. The author of the work is the owner of the copyright. However, there's a couple of situations where that may not be the case. One example is in an employer-employee relationship. We have what is known as the work for hire rule in Canada. So if a person is employed for the primary purpose of creating a work, at that point, they are not the owner of the copyright. Instead, it is their employer who is presumed to be the first owner of the copyright. Now, you're probably wondering, well, what can I do to overturn this presumption? Well, one thing that you can do is, if your intention is to be the owner of the copyright, make sure that it states very clearly in your employment contract that although you are hired to create a certain work, the parties agree that you as the author are going to be the first owner of the copyright and not the employer. Now, if you're hired to create a work, I don't know how well that's going to go over, but just know that that's one of the things that you are going to be agreeing to, is that your employer is the first owner of the copyright, even if it doesn't explicitly say it in your contract, because there's a presumption under the law. Now, if you're fine with giving away your copyright, that's one thing. And oftentimes it's understood that that's kind of part of the game if you're going to be hired to create a work. If you're, for example, an author that is well-renowned, has a huge reputation, and you at that point have a bit more of a bargaining chip. So if you enter into a relationship where you are giving up your copyright in an employer-employee relationship, perhaps the way to handle that would be to negotiate a higher monetary compensation. So a little bit more money, saying, look, I'm not going to contest the copyright issue, but you're going to have to compensate me for the rights that I'm not receiving. So I think the important thing to take away from this is that know when you have rights, know when you don't have rights, and know how to negotiate to bridge the gap. Another important relationship that we should look at is consultants, contractor, subcontractor, any kind of contractual relationship that you're going to be entering into with your clients. So in this situation, because there isn't an employer-employee relationship, but rather a contractual relationship, it's the contractor, consultant, subcontractor who remains the owner of the copyright. However, if there's a clause in the contract that assigns the copyright, that gives the copyright away to the client, at that point, obviously, the contractor or the consultant is not the owner of the copyright. It would be the client to whom the rights were given. Again, in this situation, this is an excellent opportunity for negotiation. And depending on what the work is, sometimes it's better for the client to just have the copyright so they can do what they need to do with the work. The last item is any other person. As you've seen in all of these relationships, the economic rights are really tied to the copyright. So as part of the copyright owner, you have the right to assign those rights to any other person for whatever reason. So the owner of the copyright then becomes whomever you assign those rights to. What about in situations where there is a number of people who are working together on the project? So works of joint authorship. So this can fall into two categories. You've got works of joint authorship, which is defined as the collaboration of two or more authors in which the part created by one is not distinct from that created by the other, or the others if there's more than one. So what does that mean practically? When you look at the work as a whole, you're not able to tell at first glance who did which part. It just looks like one final piece. An example that comes to mind is, imagine a painting where you're seeing it in a gallery, and you can't tell just by looking at it. Maybe one author only painted the yellow parts, where another author painted the blue parts, but you wouldn't know that just by looking at it. It just looks like one painting. This is in juxtaposition to what we call a collection. A collection is one work composed of separate parts by different authors. So some examples that would come to mind is like encyclopedias where different authors do different chapters, and it's pretty easy to tell who's done what because it's clearly stated. You can tell the tones are different. You can tell different people with different expertise wrote it. Another example could be newspapers, which is a collection of articles by different journalists, or journals, magazines, periodicals, any kind of what we would call a collection, where different authors would put their works together. And it's often quite apparent just at first glance of the work that it's made up of a bunch of smaller parts. And you can often tell who's done what and where their copyright starts and where their copyright ends. So one important thing that we need to discuss of these two distinctions is that in the first situation, work of joint authorship, the copyright would be split what we call jointly and severally, meaning that each author is going to have the same parts of the copyright whole. So for example, in my example of the painting, if there were two artists that created the painting, they would each own together one half of the copyright. What does that mean practically? That means if author A wants to sell the painting, he needs to speak with author B, and they need to agree together to assign those economic rights, because you can't assign one half of property or else the property won't properly be assigned. The person receiving that copyright will not have the entire right. They only have a part of it, which means that they're going to be in the same situation as author A. If they want to do anything with the work, they need to go see author B and say, please give me your permission to do what I need to do. That's usually not a great situation to be in. It's kind of like if you've got des colocataires, like people who are working together, renting a space together. You can't just invite friends over. You have to speak with your roommate first.
Sorry, we have a question in the chat from Catherine. Catherine,
yes.
Can you open your mic, please, and ask your question?
Hello, can you hear me?
Yes, hi, Catherine.
Sorry. I was just thinking about the last point still, and my question is just to clarify: does an artist only have the economic and moral rights, like only if they paid and registered for copyright? I think I missed that part.
No, you're absolutely right. So let's just pop. Actually, can we pop? No, we don't need to. So you're absolutely right. Copyright in Canada exists whether you register it or not. So copyright, the moment that you create an original work, as we discussed before, the copyright automatically exists. I'm not sure if you've ever heard stories of people back in the day, they would write songs or they would write a novel and they would mail it to themselves to make proof of that date that the work was created. Well, that is because they have what is called common law rights, meaning your right exists on its own automatically under the law as soon as the work is created and fixed. And the reason they would mail themselves the work is so that they have an official date on when that work was created. So if someone then stole their work and tried to pass it off as their own, they could pull out that envelope from the mail saying, look, I've got proof that I created this before, therefore I am the lawful owner of the copyright. So which brings us to the second part of your question. What is the purpose of registration, or why on earth would you register? Well, the thing with registration, it's kind of like the legal equivalent of sending yourself the work through the mail. You've got official proof that you are the copyright owner of the work. And I believe we're going to touch on that a little later as to why you should register your work, but just briefly. There's a presumption of validity. So your if you find yourself in a situation where someone is contesting your ownership of the copyright or is saying that you're not the real owner of the copyright, you've got a couple of things in your corner when you have a registration. You've got a presumption that the right exists, that it belongs to you. You've got a clear timestamp, so you know exactly when you registered it, and as of that moment, the right was given to you. You've got the right to use that. Essentially, it's a monopoly on your copyright on the territory of Canada, as copyright is a federal jurisdiction. So there's a couple of reasons why people go ahead and file the copyright. I should also mention, and this is particularly useful if the copyright that you're dealing with ties to software. In Canada, contrary to the United States, you don't need to file a copy of the work in order to obtain your copyright. All you need to do is fill out a form that states the author, I believe it's their address where they live, if they're Canadian, and the date the work was created. And based on that information, CEPA will grant you a copyright. In the United States, you actually have to attach a copy of the work. So what ends up happening is that work becomes public. So in Canada, if you're dealing with something like software that you may not necessarily want to broadcast to the entire country, you can still obtain your copyright without having to file a copy of the work. Ketan, have I answered your question?
Yes, thank you so much.
No problem. Oops, let's just to complete the thought on the works of joint authorship. So we're juxtaposing the two different rights. Works of joint authorship is where you've got a shared copyright between a number of authors. A collection instead is a very, very different situation. We can take our example of newspapers where each author would have a copyright only on their part. None of those authors would have copyright on the entirety of the work. Now, there's an entire school of thought with respect to who owns the copyright on the entirety of the work. Oftentimes it would be given to the person or the entity, if in this situation, if it would be a newspaper house, for example, who puts all those pieces together, they would have the copyright over the entirety of the work. There's a different school of thought that says, no, each author retains the right to their specific part, meaning that, let's say the newspaper house wants to assign the copyright to a third party, they'd have to get an assignment from each one of those authors. The easiest and best way to deal with that is to just get a contract. Write what you need in the contract if you want everyone to assign the copyright to one entity, and then that entity then deals with how to deal with the copyright afterwards. That tends to be the easiest way. But just know that if you're part of a collection, as an author, your copyright only extends to the portion of the collection that you contributed. So let's take a look at works of joint authorship. And we have a famous case on this issue in Quebec. there is a multimedia scenic work. Think like a theater piece with lots of lighting and choreography and music, created by Monsieur Gilles Maheu in 1988. And this piece was called Le Dortoir. This has been a particular case because, as I mentioned, it's multimedia. So there is the theatrical piece, there's the script, there's the music, there's the lighting, there's the choreography, there's the costume work. So the question is, with all these different elements, what kind of work is Le Dortoir? Is it a work of joint authorship, or is it more of a collaboration where each author would own their specific piece? Does anybody have any thoughts or wants to jump in and try answering the question? Maybe the question was too hard.
Is it a collaboration because it's a unified piece?
That is a very good thought. So an argument could be made that somebody sitting in the theater would watch the show much like you would watch any piece of musical theater like Rent or Wicked, where all the pieces work together. So that is a very good point. But can we make an argument for maybe works of joint authorship? Does anyone want to try and make an argument on that point?
Maybe I could try.
Yeah, please.
If it was joint authorship, for instance, the costume designer, if they wanted to use the costumes or exhibit them in some other situation, they would need to ask permission to Gilles Maheu and maybe the dancers in that case. But I'm not sure though if they would actually need to do that. It would seem really complicated unless those maybe if those costumes were really associated to the idea of Gilles Maheu, maybe then they would really need to ask permission.
So Lydia, I think you make a very excellent point. And let's take the example of the Lion King musical. I'm sure everyone has heard of it at the very least. The costumes in the Lion King musical are so iconic, that puppetry, that, the Simba's mane. If someone were to take that costume and use it in any other musical theater, I think immediately would say, that's a Lion King costume, right? So in that aspect, maybe there's some arguments to be made for works of joint authorship. So that's a very good point, Lydia. So here's what happened before the court. And as you can see, this went all the way up to the Court of Appeals. So this was a question where there was lots of back and forth. So the issue really happened with an individual named Michel Drapeau, who was the songwriter. He created the music. He created an original score to accompany scenes of the show. So originally, right out of the gate, it was agreed that Michel Drapeau, the songwriter, would have the copyright of his music. However, there's some interesting points in how he worked with Monsieur Maheu. He didn't have any latitude in his performance. He didn't have any latitude in the creation of the music. So what does that mean? It means Monsieur Maheu is the one who had all of the control. So he would tell Monsieur Drapeau, I want you to write this type of song. I want you to get inspiration from this type of work. It needs to sound like this. It needs to hit these types of certain points. So when you hear that level of control, you should have a light bulb go on and say, oh, maybe they were in an employer-employee relationship. So when that happens, what happens to your copyright? It doesn't stay with the author. It might move to the employer. So let's just park that for a moment and just take a look at the other facts. Gilles Maheu was really giving a lot of instructions to Michel Drapeau. He also controlled how the pieces were put into the play and how they were changed. So it was more Monsieur Maheu that was making modifications to the music than Monsieur Drapeau. Of course, what do you think happened? The two got into a fight over who owns the copyright. Monsieur Drapeau, the songwriter, ended up suing Monsieur Maheu, saying that not only does he hold the copyright to his music, but because his music is an integral part of the entire work, he owns the copyright, or a portion of the copyright, jointly and severally with everybody else of the entire work. That includes the choreography, the staging, the costumes, the lighting, you name it. So, in his point of view, this work was a collaboration that each individual part could not exist on its own. Of course, Monsieur Maheu was very strongly opposed to this and said that that was not the case. So which way did this break? Unfortunately for Monsieur Drapeau, it did not break in his favor. And this was the reason that the court gave. When viewing the work as a whole, what ended up happening was that this was not a piece of musical theater like you would think The Lion King, for example. In The Lion King, because it's so sung through, if the music was removed, it would be really awkward to see people singing without any music. So in that respect, the music is an integral part. In this particular case, the music was easily removed, easily replaced, so it was not considered an integral part of the work. So the work wasn't affected by the removal of the music. For that case, it was considered more of a collaboration and not a work of joint authorship. So Monsieur Drapeau's copyright only extended to his part of the music and not the entirety of the work. And of course, as you can expect, Monsieur Maheu was not pleased at being sued all the way up to the Court of Appeal. So what he ended up doing is just removing Monsieur Drapeau's music altogether. And I believe he replaced it with something else completely different. And it didn't affect the play at all. So this case is interesting because it illustrates how the facts work closely with the law. So you've got your main principles of law, works of joint authorship, collaboration, and then you've got the nitty-gritty of the facts. And that's one of the important elements that you need to know the court really does, is they'll check every fact and see how does it fit into the test. And it becomes almost like a point system, right? So how many points do you have for works of joint authorship? How many points do you have for works of collaboration? Which one is going to tip the scale? And in this case, luckily for Gilles Maheu and not so lucky for Monsieur Drapeau, it went the way of collaboration. So here are just a quick summary of the main points that came out of the case. No intention of co-authorship. The music is distinct from different parts of the show. And, I didn't mention, at the very beginning, there was that element of control that Monsieur Maheu was exercising. Because of that, there's that subordination link. So when you've got that subordination link, it's going to push you more towards the collaboration because the authorship clearly wasn't meant to cover the entirety of the work. It was really just meant to cover that one part. Okay. So now you've got your copyright. You know what to do. Do you know what to do with it? So what should you do? We spoke earlier about registration and about why registration is important. The question is now, do you need to register? Like we mentioned earlier, no. Your rights exist, as we say in French, de plein droit. So under common law rights from the moment the work is created. As I mentioned earlier, registration is desirable in certain circumstances. More so if you think that you might want to assign your copyright, it appears better if your copyright is registered, in the sense that the person who's going to be buying your copyright from you has that comfort saying, okay, well, I know that if anything happens, if I get sued, at least I have a copyright registration to fall back on. What happens, though, if you don't want to register your copyright and you do get sued? In that case, you have to rely on facts. So what should you do? Any element of proof that you can collaborate, you can pull together from the moment that your copyright is created, from the moment your work is created, to make proof that you are the copyright owner, is how you make proof of all of those facts. So I know it sounds silly, but that back in the day when they used to mail themselves copyright, that is still a very good way of making proof of the date that you created the work. Only you maybe don't have to mail it to yourself. You can email it. That'll work just as well. any discussions that you have with people regarding your work. Let's say, for example, that you are collaborating with someone. Keep a track of all those emails so that it's very clear, should you get into a fight, who did what the contribution, and what was the intention of the parties when you first created the work. Was the intention to have joint authorship, or was the intention more to have a employer-employee relationship? Was it a work of collaboration? All those things can really be seen by the way you communicate and what your intentions are. Also, it's important to be weary about saying, oh, if you collaborate with me on this, I'll give you all of my rights, especially if you're doing that in writing, because that can and likely will be used against you in the future if you get into a fight with someone. So just be mindful of how you're communicating with people, especially if you're communicating in writing, and important that if you do want to hold on to your rights, having very cordial, very clear communications in writing is important, because as they say in French, les paroles s'envolent, mais l'écrit reste. What is said is easily forgotten, but when you have written proof of what's going on, at least you can always pull that out later, not even for if you end up in a conflict, but even just for yourself, so you have a paper trail of what happened, who owns what. It makes everybody's life a little bit easier, and your lawyer as well in the future if ever you need to get one. Let's say that you have your registration, or you don't have your registration, and you want to advise the world that there is a copyright registration or that copyright exists. Well, you can use legal notices, the little C with the circle. You can use that. You can also use deterrence, and you'll see this at the bottom of many people's email, like all rights reserved, reproduction in whole or in part strictly prohibited without consent. You're essentially advising the world that you are the copyright owner. If they want to use your work, they can, but they really do need to obtain your permission, and they need to do it on your terms and conditions first. So do you have to use a legal notice? Do you have to use a deterrent? No, it is completely up to you. Is it recommended? Yes. It is, because at that point in time, you're showing the world that you acknowledge that you're the copyright owner and that you are taking steps to protect your rights. Another thing that you can do is, and you'll often see this on artwork, you've got the watermarks, copyright or sample or whatnot. So that's another way of just protecting your work and making sure that people are aware that there is a copyright. The flip side of that is that if someone does go through the effort of removing the watermark, removing the deterrent, and copying your work, now not only would you have copyright, not only can you enforce your copyright against them and say you need to stop using my work, but in addition to that, you're going to have what we call access to damages for bad faith. So not only did they copy your work, but they did so knowingly and with the intention to copy your work. They knew that there was a copyright, and they still made efforts to remove the copyright notice and to copy the work. So you can try and go and get elevated damages to evidence that they've acted in bad faith. And the court will often see that in a very poor light. If someone's made efforts to contravene electronic protections, to remove copyright notices, the court will take note of those facts, and you will be in a position to push for higher damages or to push for stricter consequences for the infringer. So now you know where copyright exists. It's important to know that, especially in Canada, we have a large number of exceptions to copyright. What does this mean? There are cases where third parties can perform acts that are normally reserved for copyright owners, but without having to get the copyright owner's permission and without fear of being liable for copyright infringement. Now, there are a large number of exceptions provided in the Copyright Act. Some notable categories are what you see up on the screen. So backup copies. So what does backup copies mean? If you're copying files to save for a future in the event that the system crashes, that's not considered copyright infringement. Non-commercial user-generated content. For example, for yourself, if you just wanted to take a picture of a work online for your own personal needs, not something that you're going to be presenting or performing just for your own personal use, that's usually okay. Fair dealing, and we're going to look at that a little bit more in detail in a moment. Reproduction for private purposes, that's usually like studying, that sort of thing. And incidental inclusion, that's an interesting example that contradicts what we were talking about earlier. That's if, for example, for some reason that you accidentally caught a copyright work in your particular work without intending to. Something that we can imagine could happen is if you're, for example, filming a YouTube video outside on the street, and as you're filming, a car drives by and they're blasting a song on the radio, and you catch a few seconds of that song in your YouTube video unintentionally in the background. That wouldn't really be copyright infringement because it was unintentional. You had no intention of using that song. It just happened that the circumstances, someone drove by, you caught a few seconds of the song in your video. It happens. So if it's incidental inclusion, no copyright infringement. However, if we go back to the exception we had before, where someone intentionally uses a song, removes the copyright notices, and does everything they can to copy that work, not only, as I said before, are you violating copyright, but you can have some dire consequences. Let's take a closer look at fair dealing, because I think this is probably the most interesting exception. So what is fair dealing? It is entirely acceptable to use a portion of the work in your work or in whatever use that you need to do it, provided that it is for an allowable purpose and the use is fair. So what's that mean? Let's look first and foremost at the allowable purposes. So we have a Supreme Court case that lists the purposes that are known as allowable under the fair dealing rule. So these purposes are private study, research, education, parody, satire, and critique or review. So that you can imagine that as being something that you would see on the news, right? They'll play an excerpt of something and say, okay, let's critique what was happening. However, it's important to note that if you're going to do a critique or review on, for example, a song or a movie, you have to indicate the source of that work and the name of the author. So there's 6 criteria in order for fair use to apply to any of these purposes. Now, again, as with copyright, these are factual, heavy tests. So that means that different facts can push the test in either direction. So these criteria are the purpose of the use, the nature of the use, the extent of the use, alternatives to the use, nature of the work or creation, or effect of the use on the work. How do these criteria work together? Well, we have to check, for example, what's the purpose of the use? And I put up on the screen teachers ? This is a really great example because I find, especially for copyright, teachers are probably the most known to use the fair dealing exception. I don't know if you're aware of CopyBec that we have in Quebec, that is gestionnaire des droits d'auteur, and what they do is they, for print books and whatnot, they will track the use of the copyright and make sure that if anyone needs to pay royalties, they're doing so. So CopyBec and the teachers unions tend to be on opposite sides of this discussion. Teachers will often push to have the fair use exception, and they'll make photocopies of works and give handouts to their students. And CopyBec, on the other hand, will push back and say, whoa, if you're copying more than X number of pages, even though it's for an allowable use, which is education, you're using a huge portion of the work. Therefore, you are violating copyright. You need to pay royalties, or you need to get an assignment or whatever, or buy the book. So why does that happen? Well, one of the criteria is about use, nature of the use, and extent of the use. So what does that mean? Well, nature of the use is different from purpose. It doesn't mean why you're using, but how important is the portion that you're using? That contradicts with extent of the use. So you've got how important is the part that you're using and how much are you using? A really good example is when people play songs in shows. How much of the song is being played? Let's say on a 2-minute song, you're using 15 seconds. That's a very small portion of the song, so that kind of skews in your favor to say, yes, the use is fair. What if I were to tell you now that those 15 seconds are the entirety of the chorus? Now you're using a very important part of the work. Is the use still fair? The argument would be more on the no side at this point, because you're using such an important and recognizable part of the work that a person may not necessarily need to hear or see the rest of the work to get an appreciation for what it is. So you're arguably using the most important part of the work. You're making it such that a person cannot turn around and license the work because you're using it for free. So it's having an important economic impact. Is the use still fair? Probably not. So there's a big play on how all of these criteria work. And they do very much work together. Important to always check the facts, check how much of the work is being used, how important the excerpt of the work is being used. And when in doubt, always, always, always cite the source, cite the name of the author. Give credit to where credit is due, and you'll push your odds in the favor of fair use. Before we terminate on copyright, I just want to take a quick look at some transactions. So as we spoke about before, copyright, when we talk about transactions, we're really talking only about economic rights. You can assign economic rights. You cannot assign moral rights. So if someone's asking you, please assign me your moral rights, you are fully entitled to laugh at them. You have to waive moral rights. So what kind of transactions on the copyright are we looking at? Well, you can have an assignment, you can have a license, but what do these mean practically? It means that you're essentially giving people restrictions on how they use your copyright, so that those restrictions can be touching the rights, the territory, the language they use, whether it's limited in time or not. Some examples that come to mind is if you're licensing a television show, for example, would the right to license the show be a worldwide right? Would it be only limited to Canada? Are you licensing only English language rights, Spanish language rights? Is your use perpetual throughout all of time? Is it limited for the next 6 months? So these are all different questions that you can ask yourself. And there's a number of different criteria. So important that when you're assigning a copyright or licensing a copyright, know that it's not all or nothing. You can really pick and choose which elements you're giving to whom and how they're going to be dealing with those elements. Just a quick overview on some basic contracts. I think there's two really basic contracts that you need to know exist. The assignment, which is the transfer of ownership, and the exclusive license. Now, know that licenses can be exclusive or not exclusive, but the purposes of our discussion will look at exclusive licenses. The important difference between an assignment and a license is an assignment, you're giving away your rights, versus a license, you're still the owner of the copyright. You're just giving people permission to use it. So think of it more as a rental arrangement, kind of. So exclusivity, obviously, if it's an exclusive license, it will be exclusive. But know that that's not always the case. You can have a non-exclusive license, which means that you're allowed to give your copyright to many different renters. Formalities in both of these situations, they need to be written and signed. Know that if you're doing a non-exclusive license, it doesn't have to be written and signed, but it's always preferable to have a written contract just for your peace of mind, and so that everybody knows what kind of rights they have and what they can and cannot do. That way, as I said before, if you get into a fight with somebody, at least you've got something down on paper. In both situations, you'll have a right of action against counterfeiters. And like I said, you cannot assign moral rights. So if you want to waive your moral rights, you need to have a specific clause to that effect. So let's ask ourselves, what is a trademark? Trademarks are really what you would think of branding. Anything that's a word, a design, a slogan, anything that would distinguish your goods or services from anybody else's goods or services. So I put up some famous trademarks that I'm sure everyone recognizes: McDonald's, Disney, UPS, Toyota. These are all trademarks that when you see them, you know exactly what the good or service is associated with them. And that's because of the reputation, the goodwill of the trademark. So like, if I tell you that McDonald's sells shoes, for example, you would say, no, it doesn't. I know what McDonald's sells. So there's some trademarks. Important for you to know that the law has changed in the last year, and they've really expanded what can be a trademark. So we've got some what you would normally think as traditional trademarks, like the word mark. And here's some great examples up on the screen. You've got the Itzkalwa, just the word. You've got your design marks, so you can have Itzkalwa with the little blue background or the little E in the circle. Those would both be acceptable as trademarks, and you would know as soon as you would see that E what it's meant for. That's kind of like McDonald's, for example. If you would have McDonald's, the name, the word McDonald's, versus the M, the yellow M, the golden arches, that those are both acceptable trademarks. There's also other things that you wouldn't maybe necessarily think is a trademark, but actually can be registered as a trademark. So it's the product of the container or the way a product is wrapped. So one really good example is the Coca-Cola bottle. You know, when you see a Coca-Cola bottle, exactly what it is. Nobody needs to tell you that this is a soft drink. You know exactly what that is. Another thing that you can also trademark is, and Apple has done it, the layout of their store. And that was a really interesting one, because when you walk by an Apple store, I'm sure you've noticed they're all exactly the same, and they have a certain look, and they've got the long white tables. So all of that was actually trademarked in Canada for Apple. Other things that you can trademark now under the new law, the sound. So I'm sure you've all seen movies where you've got the little lion roaring at the beginning. That is a trademark of Metro Goldwyn Mayer, and that is actually one of the reasons why we do have sound trademarks here in Canada, was because of them, their push for their lion roar at the beginning of their movies. Another thing that you would think of is the Metro, when the Metro leaves, that little sound. You know that is the Metro sound. So that is something that you could trademark, because it's a sound that's distinctive for your good or service. Figurative element, that's just kind of the placing of a specific element on the product. Colors. You can trademark colors. A fun example is that red at the bottom of the shoe. That specific type of red can be trademarked, so that everyone who sees that red will know that it's associated with your specific product, but also to stop other people from copying your product. Bizarrely enough, now scents can also be a trademark. And at first glance, that seems like an odd thing, but when you think about it, and I did a very big caramel case, scent and tastes are important things to trademark. If you think about big chocolate producers and caramel producers, I mean, you know you're eating a Kit Kat. You don't need to necessarily look at the product to know you're eating a Kit Kat or an Oreo or any of those things. So they can have specific scents or trademarks specific to their brand. Holograms. Think of your MasterCard. Think of the little holograms you see on money. If your company has a specific hologram that's associated with it, that can also be trademarked. Specific textures, tastes, as we talked earlier. Even the positioning of a sign, and I use the Adidas shoe. And as you can see, you can tell that's Adidas without me having told you, because of the way the stripes are positioned on the shoe. So these are all things that can be trademarked. So when you're looking for a trademark, you got to think, what sign or word or taste or other element can I put out there that when people see it, they will automatically associate that with my brand and my goods and my products and my services. So that is essentially what a trademark is. Some key elements for trademark. Like all other forms of IP, trademark is really geographically specific, meaning that if you've got a trademark in Canada, you're not going to rush over to China and try and enforce your trademark. Your trademark really is tied to Canada. Trademarks, like copyrights, don't have to be registered. You could benefit from what is known as common law rights. Now, we were talking about in copyright that your rights exist as soon as the work is created and as soon as it's original. That is not the case for trademarks. Trademarks are tied to use. So the important thing to remember with trademarks is use it or lose it. So the more you use your trademark, the more common law rights you'll have in your trademark. What does that mean? If I'm using my trademark without having it registered only in Montreal, for example, and I never sell or use or advertise my products or services outside of the city of Montreal, I only have reputation in my trademark in Montreal. Therefore, I only have quote unquote common law rights in Montreal. What does that mean? If someone in Vancouver is using my exact trademarks, I would have a very, very weak case to say that they are creating confusion in Vancouver if I've never actually used my trademark in Vancouver. Now, That's not the case if you register your trademark. If you register your trademark, you are presumed to have a valid trademark in the territory of Canada, so the entire country. So even if you only use your trademark in Montreal, you have every right to stop someone from using your trademark in Vancouver. So that's one of the key differences with registration. Though on the flip side of that, when you register, your registration is good for 10 years. After those 10 years elapse, you're going to have to renew your registration. Whereas if you're relying on common law use, again, use it or lose it. So as long as you're using it, your trademark's valid. When you stop using it, that's a different story, but there's no registration, none of that mess that you need to deal with. So let's talk quickly about territory. As I mentioned, when you register, it's for Canada. Trademarks, exactly the same thing like copyright in terms of treaties. Actually, Canada just joined what we know as the Madrid Treaty. So we now have, you can get, I wouldn't call it an international trademark, but you can have a trademark that's registered under the Madrid Treaty that would be valid in multiple countries. And one of the advantages of doing that is it would be much more cost efficient to register your trademark through the treaty, because you'll get like a kind of a package deal situation instead of registering in every single country that you have your goods or services. So these kinds of things really benefit people who intend to have a global reach for their goods or products. So imagine Coca-Cola that wants to sell in China, Singapore, Germany, all over the world, and they don't want to pay fees for every single country. They can go through a treaty and just get like 100 countries registered all at once. Monopoly. So when you register a trademark, you have the exclusive right to use that mark. Think of it as a monopoly on your brand in the territory of Canada. When you do not register your trademark, you still have that monopoly. However, it really, really is tied to your use. So like I mentioned before, if you're only using it in Montreal, your monopoly only exists in Montreal, which means that it is very, very possible and probably likely to have a number of people using your marks concurrently at the same time in all sorts of different places. So that's something really to be aware of. Some other rights that are tied to registration that you won't necessarily get if you don't register your trademark. You have what we call the statutory right to sue for infringement. What does that mean practically? It means the law gives you the right to sue under the law for trademark infringement. If you don't register, you can still sue, but it's not necessarily for trademark infringement. It's for what we call as passing off. So someone has taken your trademark and passed it off for being their goods or services. So they're almost masquerading as you. Think of it that way. Two different types of litigations, different types of rights associated to it, but just an important distinction when considering whether you want to register or not. And as we mentioned before, when you don't have a registration, one of the difficulties is that you really are restricted to your area of geographical use, not only for what you can and can't do in terms of what's tied to your use, but also you cannot sue people outside of your use. Let me be clear. You absolutely can sue people outside of your sphere of use, but your chances for sex are going to be not worth the effort. You're going to get thrown out very quickly. So it's advised that if you intend to have products, services, etc. throughout Canada, you are much, much better to try and get your registration, because it is just easier on the evidence point of view if you need to stop people from infringing on your rights. So how do you choose a trademark? Well, you should have some ideas of what's unique to your brand, and I'm sure you probably all have ideas of what you want to trademark yourselves at. Note that you can use your own name. That is perfectly acceptable if you are the one who is exercising the goods or services. But if you're like another person would not be able to register your trademark, your name as a trademark for goods or services, you have rights to your own name. But I guess the first rule of thumb when you're looking for a trademark is to pop onto SIPO and check what trademarks exist that would be similar to yours. You can even do a general Google search. So if you want to register, for example, Hugo Boss for coats, maybe you should be aware that Hugo Boss already exists and that you might not only be causing some confusion with an existing brand, but that you might run into a trademark infringement action fairly quickly. So important to know what's already out there, what exists in terms of registrations, and what you can and cannot use. And that's something that you can do fairly easily on your own. Just take a quick Google search, quick look on SIPO, and you'll sort that out fairly quickly. You also need to know that there's good and bad trademarks, and that is very much a thing. What would constitute as a bad trademark? A bad trademark we would define as something that's very weak, not terribly distinctive, and difficult to register because it's overly descriptive. So adjectives tend to be to avoid. So if you want to call yourself the very good shoe company, you can't have a trademark that describes your product, describes the geographical location where your product is made, like the Canadian shoe company. That would be a very weak trademark, wouldn't be able to register that. Something that describes the quality of the good, so the very good or the very bad, whether that is descriptive or what we call deceptively misdescriptive. So here's a really fun example for descriptive or deceptively misdescriptive. For example, I'm a banana salesman, and I want to trademark Arctic bananas. So I've got two problems. First of all, banana is the name of my product, so it's literally describing what I'm selling, so that won't be registered. Second problem, Arctic. If my banana comes from the Arctic, then I have a clearly descriptive trademark. I am literally telling you where the banana comes from, so that won't be registerable. If my bananas come from Florida, however, and I want to register Arctic bananas, now I have a deceptively misdescriptive problem because a consumer might be deceived into believing that my bananas actually come from the Arctic. So the trademarks office will stop you from registering that. The next item is primarily a surname. This is a fun one because I mentioned before that you can trademark your own name, but another person cannot trademark your name. But I'm talking first and last name, like together. Something primarily a surname. You'll often see like Brown and Sons, or law firms often will have like Lafreniere and Company or something to that effect, right? If something is deemed primarily a surname, they will stop you from registering that because they don't want to A, create confusion with people who actually have that surname, and B, they don't want one person to get a monopoly on a surname that many people have. So the criteria really is like, do more than 25 people in Canada have that surname? If so, then the name would be primarily a surname. But an easy way to kind of get around that would be to add that like Brown and Sons, because when you've got that and Sons element, it's not primarily a surname, it's something else. And there's a number of other ways to get around it, but just know that if the most important part of your trademark is a surname, maybe ask a few more questions and consider adding some other distinctive elements to it. Names of goods or services in another language. Yes, so not only can you not use the name of a good or service in English or in French, can't use it in other languages. So if you want, like for example, mizu in Japanese, which means water, for a water bottle salesman, the trademarks office will ask you to send a translation of the word, and they will very quickly stop you from using the words in other languages for goods and services. And that's the same issue as your descriptiveness. You don't want to give someone a monopoly on the name of a good or service. That's not really fair, and that's anti-competitive behavior. Geographical indication, recognized standards. So geographical indication, like we talked about before, careful when you're using something like the Arctic, because it could be either descriptive or deceptively misdescriptive, but it's important to note that in Canada, we do have an exception where people are allowed to use Canada. So you often see some stuff like Canadian Best Western. You're totally allowed to use Canada. You can use the maple leaf. But the only thing is when you're applying for your trademark, you need to make a little disclaimer saying, I acknowledge that I do not own the word Canada. So everyone's allowed to use it. Recognized standard is also an interesting one. It's like, I don't know if you've ever seen certified products, for example, Woolworth. If something's made of a certain quality of wool, they'll have that standard. So you can't use that standard as your trademark because it can be confusing. Like Is that just a word they're using? Is it actually Woolworth? And especially if, for example, your product is like wooden chairs, you'll be like, I don't understand the connection. So yeah. And the last item is official mark, which is your section 9s. Official mark is a very interesting area, and I don't think it would be terribly applicable for you, but if essentially an official mark is a mark with a specific status that is granted to public bodies or organizations that work in conjunction with public bodies, and it'll block other people from using that word. But it's really used in very specific situations. So if you're not really of public body standing, then an official mark is its own thing. So what makes a good trademark? What we call a high degree of inherent distinctiveness. So what does that mean? How do you know that your trademark is distinctive? Well, I've got some 2 really good examples up on the screen. If I show you the apple, do you think that that is associated with the fruit? No, it's with computers. So why is that distinctive? Well, I don't think anyone would have thought to use a piece of fruit to name a piece of technology. So it's memorable. It's frankly a little weird, but that sticks in your mind. It does not describe the product at all. I mean, the phone is not shaped in any way, shape, or form like an apple. And there's I believe at the time that it was coined, there was nobody on the market that was using that kind of strategy. So that makes the trademark very distinctive and very memorable and very unique. The trademark doesn't have meaning in relation to the product or service. Like I said, avoid being descriptive, avoid adjectives. That's usually not a good idea. And try and find coined terms. So some of the most successful trademarks are made up words like Google, codex, different words that don't necessarily mean anything or are conjunctions or just different pieces put together. So those are all things that you should consider when creating a trademark. So now you've got your trademark settled, or you've got your registration, however you want to play it. What do you do after? Well, there's a number of things that you can do to evidence that you have a trademark. You can use TM or the R in the little circle. TM is for unregistered trademarks. If you want to use common law rights, the little R is for registered trademarks. There, you can protect the distinctiveness of a trademark. So what does that mean practically? Your best ally to protect distinctiveness is to make sure that nobody is using your trademark, but nobody's using something similar to your trademark. So if you were to Google, for example, Humane Society, in the trademark SIPO search bar, you would get, I think there's a Humane Society for every single city and province in Canada. So would that trademark be terribly distinctive? Probably not, because there's so many out there. So one way to protect your distinctiveness, if you've got a really unique trademark, is to make sure that nobody else is using it. Also, nobody else is using anything similar. That's why you get these very aggressive litigation tactics by the large names, like Hugo Boss famously went after a beer that was using the word boss because they just want to make sure there's nobody out on the market who's using the word boss. Apple does the same. And a lot of the big brand names would be very aggressive in protecting anything that remotely resembles their trademark, even if it's for a completely different product. As discussed before, adjectives to avoid as much as humanly possible because they can create a whole slew of issues. The concept of brand genocide is very interesting, and it's to be avoided. So what does that mean? Some people do such a great job of coming up with a distinctive trademark, of marketing it, of making it well known, that it becomes so well known, it gets adopted in normal language. So now if I were to ask you, I've got a bit of a cold, I need a Kleenex, you would know exactly what I mean. I noticed I didn't say I need a tissue. It's the same thing for Band-Aid. I don't say I need a flexible piece of fabric to stop my bleeding. I need a Band-Aid. Well, Band-Aid, Xerox, aspirin, Kleenex, these are all trademarks that have suffered from what we call genericide. They've become adopted into normal parlance, into normal language. So they've become such generic terms that they've lost their distinctivity as trademarks because we know them as the product they're meant to represent. So that's the complete opposite end of the problem, where you've done too much of a good job. So do a good job, but not too much of a good job. Okay, so in all of these situations, Oh, yes. I think I skipped licensing. So what does licensing with care mean? One of the most powerful things you can do with IP really is licensing. That's an easy way to commercialize your IP. And an excellent example of licensing for trademarks, think of franchises. You've got a company that created a concept, a brand, a franchise, and then they get a bunch of little companies under them who are going to be using that. That's the business model of McDonald's and most restaurants, where they've got the IP, the McDonald's brand, and then they've got little tiny restaurant owners who have a little McDonald's business, and they are licensing the use of that trademark. Important when you're licensing is to keep a very close eye on your licensee. Make sure that they're using your trademark in conjunction with how you meant it to be used. Make sure they're not abusing it. Make sure there's no brand genocide going on. So all of these things are important when you do deal with licensing of trademarks, is to keep a very short leash on your licensee. And when it comes to trademark, as with all forms of IP, your best defense is a good offense. So keep samples of your packaging, of your labeling, of your advertising, of who you communicate with. All of these are things that will establish use and establish your rights in the event you end up in a litigation. So how do you enforce your trademark? There's a number of things you can do. Like I said, policing is one of the most important things that you can do, probably one of the most proactive things. Put Google news alerts, have Google searches in your community, have people who are reporting to you. Just take a look, walk up and down the street if you're a restaurant owner, see if anyone else is using your trademark. All those little things are things that you can do to just keep an eye on what's going on. And as soon as you realize that someone is using your trademark, you need to act quickly, because the longer it goes on, the more you're going to have an argument of loss of distinctivity. So once you've found somebody who's using your trademark, what do? Well, you need to put them on notice, and you need to do it quickly. So one of the best things you can do is send a cease and desist letter saying, "Sir, you have my trademark. Can you please stop?" And if they do not stop, then you're going to go into one of two avenues, depending on what it is that they're doing. You can go for an outright litigation, or you can go for what we call oppositions. If let's say hypothetically their use is not just limited to they're selling products on the street with your trademark, but let's say they've gone a step further and they're like, you know what? I've decided this is my trademark now. I'm going to go to the trademark office and file a request to own this trademark. Well, at that point, then you do what we call an opposition, is where you try to head them off and you raise grounds to say they're not allowed to register this trademark because I own this trademark. So these are all little things that you can do if you notice someone is doing things they should not be doing with your trademarks. So patents are essentially a negative right. It's not a positive IP right to say, like, I am the owner of this copyright, I am the owner of this trademark. No, it's a negative right. It is a right to stop people from using your invention. So in that sense, it's a monopoly on a particular invention. It's a bargain struck between the inventor and the general public, where you say, I will tell you what my invention is, I will disclose how it works, but you can't use it for 20 years. Only I can use it. That doesn't mean that they can't use it lawfully. Like, you can sell your invention, etc. They just can't make or sell your invention without your permission. Patents, unlike trademarks and copyrights, which, as we discussed, through one mode or another will automatically exist, patents do not. You absolutely need to register your patent on your invention, and you need to do it in a specific time frame, or you will lose your rights. So very important to remember that. Important question: what can you patent? As I'm sure you can guess, not everything is considered an invention, and not everything, even if it is an invention, is patentable. So we're really looking for new, non-obvious, useful inventions. It's got to be some kind of a process or a machine, a manufacturing or composition of matter, or, and this is a very common one, some kind of non-obvious, useful improvement on an existing invention. So what does that mean? It means that you cannot patent the internet. Please do not try. Too many people have tried. It is silly. It does not work. Do not patent the internet. The internet is known. It's no longer new, and it is no longer considered a useful improvement. It exists. So the fact that it is novel, the fact that it is new is a very important criteria. It also needs to be useful. which means it needs to actually work and operate. So imagine a perpetual motion machine. Everybody wants to create one. That would be an energy efficient wonder machine. But nobody has actually found one that works. It only exists in theory. So if it doesn't work, you can't patent it. And it needs to be inventive. There needs to be some kind of spark of ingenuity. And we're going to see this theme come back as we saw in the copyright. It needs to be some kind of work of the human spirit, some spark. And when we're looking at patents, how do we know if something is inventive? Well, it needs to be non-obvious to someone of average skill in the field of invention. So what does that mean? Perhaps they've come up with a new drug to cure X disease. To you and me, it's likely not obvious because neither of us have a PhD in microbiology or chemistry. But to someone who does have a PhD in that field, who's been working in the field for 20 years, if they still would not have come up with the solution that was found, at that point, you've got a really good chance that your solution is in fact inventive. So someone who's working in the field, and it doesn't have to be someone who's a genius, who's super inventive. We're just looking, the test is usually what we call the lazy intellectual. They have the skills, they have the knowledge, they are able to understand what the solution is, but they couldn't or wouldn't come up with it on their own. So what can you patent? And this is more practical applications. So you can patent a product. So we've got the example on the side, a door lock, and imagine the little piece that goes in and out when you're closing your door. You can patent a composition. So some kind of a chemical composition. Let's say you wanted to make lubricants for door locks and you found an extra slippy solution. Well, that's a new chemical composition that you've put together. You can definitely patent that. An apparatus. So a machine that makes door locks. Maybe this machine has a new way of putting the pieces together. It's more efficient. Etc. A process, so a method for making door locks. Perhaps you've thought that if you put piece A, B, and C together, rather than in that particular order, rather than the way it's always been done, it makes for a stronger lock. Then at that point, you've got yourself a process, and that's inventive. And like I said, this is the most common type of thing that is patented, an improvement on any of the above products. And 90% of all new patents in Canada are actually improvements on a product, a composition, apparatus, or a process. So you don't need to reinvent the wheel. You just need to reinvent part of the wheel, I guess, improve upon the existing wheel. So fun way to remember what you can patent. So what is not patentable? Well, scientific principles. So you cannot patent, for example, the theory of relativity, the theory of gravity. Those formulas will not be patentable. Any abstract theorems, mathematical formulas, or methods of medical treatment. And the last one is particularly interesting because you'll often find, like, for example, if someone has created a new medication to cure or treat a particular disease, they'll say, for example, take 2 aspirins to solve headache. So what exactly is it that's being patented? Is it the aspirin or is it the take 2 aspirin? Well, that can be tricky. And one of the reasons why we're very careful about not patenting methods of medical treatment is because what if your aspirin wants to be applied to a back injury? Maybe at that point you need to take 4 aspirin. Maybe at that point you need to take 6 aspirin. What if your aspirin, instead of 200 milligrams, is in pill formats of 500 milligrams? At that point, taking 2 aspirins could be particularly dangerous. Everything that I've just told you with something that would likely come out of what a doctor would do, a medical professional, based on the symptoms of the patient. So we don't patent methods of medical treatment because that really comes out of the professional responsibility of health professionals. And unless you are a health professional, it would be very dangerous to patent that sort of thing. And B, it would be better left to health professionals to understand what the drug does and to prescribe it according to the treatment plan of the particular patient. So that is a liability reason, an insurance reason, and just a danger to the general public reason. So methods of medical treatment are off the table. However, and Amazon has taken advantage of this, it is entirely fair game to patent business methods. So you're probably wondering what on earth is a business method. And if you look up into the corner, I've got your add to shopping cart, buy one with one click, or click twice. So this whole clicking on links created somewhat of a firestorm in the US because Amazon managed to get what was known as a business methods patent. So the controversy began in quite a while ago in 1999 when Amazon sued its rivals over infringement of its one-click ordering system. So you click once, automatic order. This technique allowed customers to complete online orders with just one click of the mouse using delivery payments that are stored directly on Amazon's website. So the court agreed with Amazon that it was in fact the one-click business method belonged to Amazon, and that Barnes and Nobles and the other companies had to add a cosmetic second click to not infringe on Amazon's patent. I think we're starting to get a bit of insight in how they managed to corner the market so quickly. But just so that you know, business methods are totally fair game when it comes to patenting. So some key principles. Patents, as I mentioned before, are really statutory rights under the Patent Act. So what does that mean? Is that it means that they don't exist de plein droit or under common law rights. So you absolutely do need to file your patent in order to have access to those rights. And what are those rights? That's a monopoly on your invention for 20 years from the date of the filing date or the claim date, depending on how you filed your patent. It's a monopoly to make, use, or sell the invention in Canada. Again, and this is a recurring theme with all IP, there's no international patent, there's no international trademark, there's no international copyright. It is really limited to Canada, but you can make use of treaties to try and get what we call PCT applications and get filings in different countries that are expedited. Another important thing, if your intention is to get your patent, you need to keep your invention secret up until the time that you file, or at the very most, up until 1 year before you file. What happens if the whole world knows about your invention, you display it in your front yard, you go to trade shows and say, look how brilliant I am, and then 2 years later, you file a patent? Well, the patent office is going to tell you, because of your prior and enabling disclosure, you are no longer entitled to the patent rights because you have made your rights public, and the world is already aware of this invention. Because 2 years have passed, it is now considered obvious. So, rule of thumb, tell nobody. Tell nobody about your invention until you decide to file. At that point in time, you're good to go. Now, it's important to note that when I say tell nobody, that does not include your lawyer and your patent agent, because I don't expect anyone to file a patent by themselves. It is a very difficult process. It requires a lot of technical expertise. So your patent agents that will help you and your lawyers are not considered the general public, and they are bound to secrecy. So they will help you file your patent, and you will not lose your, it will not be considered public disclosure if you discuss with them. But just don't tell your neighbor and don't display anything on your front yard. So now you've got your patent. What do you do with it? Well, like most IP, one of the most powerful things that you can do to commercialize your IP is to license, to manufacture the product, to sell the product, and importantly, to stop others from manufacturing or selling the invention. The more need that you create in the community for your invention, the better positioned you are to commercialize. If you're not in a position to manufacture the product, you can also license the invention to manufacture by a third party, and at that point, you will collect royalties, right? You can assign the patent, you can sell the patent, and that's a very good strategy for a lot of companies. What they'll do is they're in the invention business, so they'll create lots of inventions, make lots of patents, and then identify players in the industry who may have the capacity to create those inventions, who may already be in those specific industries, and just sell them the patents and be like, down payment, X amount of money, here you go. Thank you very much. Happy doing business. So that's another business strategy. These are all different ways that you could commercialize your patent. Industrial designs. So industrial designs are a bit of a strange creature. I'd like to think of them somewhere between a patent and a trademark. The purpose of an industrial design is really to protect the visual feature or shape, configuration, pattern, or ornament of a product. And it's applied to a finished article, usually by hand, by tool, by machine. So if you can look at the side of the shoe, it's that like lattice pattern that you see, or an interesting shape. So if you look at the chair, normally a chair would have like 4 legs or 3 legs, like a stool situation, but this is an interesting shape. It's got that curve going forward. So industrial design is really, we're looking at the visual feature, the shape, the configuration, the pattern. So if you've come up with a really interesting shape, then maybe consider an industrial design. So I love this example because this is a really cool looking bike, but it really illustrates the point of what a unique design would be. So this bike here is an excellent example of an industrial design. So it's all about the visual design of the article. It must have features that appeal to the eye. But to be eligible for registration, you have that element of originality that needs to be there, much like you would in a copyright. So your design needs to be original. Why would you want to register in industrial design? Well, as I'm sure many of you know, the more a product looks unique, the more you'll have a chance to appeal to a certain subset of audience, and you'll have an interesting commercial angle to exploit over there. So products, it's not only what they do, but also how they look that can be very important. Industrial design, a lot like a patent, you need to register in order to benefit your rights. So unless you register, you cannot make a legal claim of ownership. You have no legal protection to prevent others from making, importing, renting, or selling the article to which your design is applied. So if you do register, you've got exclusive quote unquote monopoly for up to 10 years. Again, is limited to Canada, but you can go through a treaty, you can get through registration in other countries. Absolutely cannot make a legal claim without registration, so you need to register. But on the flip side, there's no time limit for registering. And here's an important caveat: as long as your design has never been published. If your design has been published, now you find yourself in a similar situation as a patent. You've got to file your registration within 12 months or it's game over. So if your design is not published, it's hanging out in your drawer somewhere, you're good. You can register whenever you want. If you have published, 12 months or you lose your rights. So make sure do not miss that deadline. So what can we register as an industrial design? So we're thinking of patterns in wallpaper. We're thinking shapes of a perfume bottle. Ornamentation, maybe you've got some funky design on a t-shirt sleeve. Visual features like we saw before, the lattice work of the running shoe, or think of Crocs. They've got like all those holes. That would be a great industrial design because it's a very unique shape. What is not registrable? Anything that really touches functionality. So the minute that your visual element is not just for the look, but has some kind of functional use, you cannot register as an industrial design. So one example that I can think of is at the bottom of bottles, you'll often have that little, it's like a ring that's very rough, and it looks like it pops out a little bit under the bottle. And you'll see this mostly in older wine bottles or vinegar bottles, etc. And it's like a little bit bumpy. You would think that should be registered as an industrial design because it has like a specific look to it. But in reality, the purpose of that little bumpy bit at the bottom is to stop the bottle from sticking to the top of a bar surface when wet. So because it serves a functional purpose, then it is now disqualified as being an industrial design. If the material is what is causing the specific pattern or quality that you want to protect, then again, we're going to more of a functionality use, and it wouldn't be registerable. The idea of putting advertising on bus shelters. So similar like your copyright, if it's touching an idea and not a physical fixation, if it's touching anything that would be covered by another law, like more of a trademark situation, then you're better off going for your trademark and not so much an industrial design. The last area I wanted to touch on is trade secrets. Now, the reason I want to talk about trade secrets is because it is what we would call more your soft IP. This is not IP that really would be registered. This is not IP that exists in any form of legislative protection. So it doesn't come from the law. You won't get any statutory protection. It really exists in the fact that the secret remains secret. The minute the secret is violated, the minute it gets out there in the public, you've essentially destroyed your IP. So what exactly is protected by trade secrets? Confidential information. And that has a very large meaning and can apply to a number of things. So what does it protect? We're thinking formula, processes, designs, any information that is not generally known, but that a business can use to obtain an economic advantage over competitors. Important confidential information is not something that a competitor can find out on their own. That has a huge meaning, meaning it's not available in the public domain. If I can Google it and find it, it's not confidential. If I can reverse engineer, it's not confidential, meaning if I can look at your product and figure out how you did the thing that you did, no longer a trade secret, no longer confidential information. And just to complete on that, if someone does manage to reverse engineer, you cannot then sue them for actually, rather, I should say that is your best defense to a lawsuit for violation of trade secret, because unless the person can prove that you've somehow managed to steal their secret from them, either through an employee, through internet attacks, some kind of hacking, and they say, no, actually, I just looked at your product and was able to reverse engineer, then you've got no grounds to keep pursuing them. So some really fun examples of well-kept trade secrets are the formula for Coca-Cola. And there's always a fun story that comes out of China for the gong makers. There was a family that had a specific way of making traditional Chinese gongs, and they managed to keep this trade secret for hundreds and hundreds of years, and it was just passed down from through the family for years and years. And that's one of the pluses of trade secrets, is that if your protection is well done, then there's no time limit to how long that secret can last. So what do you do to create a trade secret and maintain it? So in our modern industries, what you'll normally see is trade secrets created by contractual relationships or implications. So what does that mean? I'm sure all of you have seen detailed employment contracts before, and there is always somewhere in there a clause that will say, we'll talk about confidentiality. That'll say, in the course of your employment, you will likely get access to some kind of confidential information, and you are contractually required to keep that information secret. You cannot disclose even after you leave. So that's one way that people protect their confidential information. They will restrict access, meaning that in that information will be on computers with passwords. Only employees who need to see it will see it. By implication, meaning, I'm not sure if you're aware, but in Quebec, we've got loyalty duties to an employer. So that'll be like, even if you leave your employer, you still have an obligation to not disparage and destroy their business, et cetera, et cetera. So all of that works together in how to protect a trade secret. Now, the obvious question would be, well, wait a minute, what if I'm not in an employer-employee relationship? What if I'm in any other type of relationship? That could be, we're litigating, we are contracting with somebody to do X, Y, and Z, any other relationship you can think of. One very easy way to protect your trade secrets is, again, through a contract. And I'm sure you all know what I'm going to explain shortly is the NDA, the non-disclosure agreement. So I'm going to let X person see my confidential information, but they have to acknowledge that A, this is confidential, and B, they have an obligation not to disclose, because if I find out that you have disclosed, you are in big trouble, sir. So that is one clear way to protect your rights. And when would you normally see a non-disclosure agreement? Well, in the artistic field, you will have a lot of artists will sign this if they're working on a show, for example. And as you know, television shows are filmed months and months and months in advance before they're released to the public. So you'll probably have a non-disclosure agreement to not talk about the show, not talk about details of the plot, until which time, they start doing the press routes. Same if you're working on video games, you can't talk about the characters, anything that you're designing until press starts. What if you're selling your business and your main IP is a trade secret, a special formula to, for example, create rubber, and you need to have potential buyers come visit your plant? Well, before anybody enters your plant, you need to have them sign an NDA to make sure that whatever they see stays with them and doesn't get disseminated abroad. And it's the same for tech companies. If they're letting people come visit for employment reasons, for sale reasons, everyone's going to be signing an NDA. I can guarantee you that. So what do we have in terms of duration for trade secret? Like I said, the family in China, they kept it going for quite a long time, and potentially indefinitely if you manage to keep it secret. On the flip side of that, what are the most common ways that a trade secret is violated? Well, a number of the cases that I have seen where there's been a risk or a potential violation is when a key employee leaves a company and goes to work at a competitor's. Now, you know that they have seen the trade secret, you know they've had access to all that confidential information, and now they're playing in your competitor's backyard. So there are questions at that point. Are they using that trade secret or not? So it becomes an entire pickle for companies who have to now go and see what that person saw, what they had access to, and can they find evidence on the market of their trade secret being used? It's a whole thing. And it's so, on that note, keep your secrets close. Do not disclose to anyone, or disclose only on a need-to-know basis. Some elements to remember if you're trying to figure out whether something is or is not confidential information. Some elements that we discuss about tied to confidentiality says it has a necessary quality of confidence about it, or it's disclosed in a circumstance importing an obligation of confidence. That's a very technical jargon. I guess the best way to remember is, if I were to disclose my secret, would I still have IP? And if the answer is no, then it's probably confidential information. Like I had mentioned, you can't register trade secret, and it would be a terrible idea to do so. Could you imagine registering on a national plan a trade secret? Be like, oh, by the way, here's my secret formula. That would be the registration would destroy the point of the IP. So what instead you should do if you want to protect is put very strong confidentiality clauses in all your employment contracts. Make sure that your customers, any contractor, any outsourcing service provider, whatever it is that you're doing that may have access to this, has a very strong obligation to keep it secret if they do happen to see it. Make sure, and this is important for that key employee that decides to go play with your competitors, put a non-compete clause. Stop them from going to play with your competitors, work with your competitors for a reasonable period of time, 2 years, 3 years, enough time that you could take action on your end to either beef up your trade secret or make sure that any disclosure of the information they've seen will not hurt you in the future. So I'm going to throw up a quick summary of the different kinds of IP that we talked about today up on the board. If anybody has any questions, comments, concerns, that would probably be the moment to discuss anything in detail. We've got about 20-ish minutes left. So yeah, I'm happy to answer any questions that you have.